Hello everyone. How are we all doing? Good evening.
Good evening, ma.
Good evening. Who am I speaking with now? Okay.
Good evening.
Benitayo. Good evening, Ineka. Good evening, Jane. Good evening, Ayodele. Good evening, Ma. So Mrs. Chinasa is here already, and we'll be going straight to her presentation because she has just 30 minutes to spend with us. So I would have gone ahead to read her profile, but because of the time that we have, I will not be able to read it, but I would like us to know that Mrs. Chinasa Uwanna is
The hottest DJ.
Associate. Let me see. Someone is here. Okay, so that was Busola. Please, let's just try to mute ourselves so that we are not interrupting the discussion. So I was trying to say that Mrs. Chinasa Uwanna is a senior associate with Banwo and Igadolo firm. She's a lawyer, she's a technology, media, and entertainment lawyer. And she'll be talking to us today about trade secrets and about confidential information. So please let's listen and be ready to ask our questions when she's done. You're welcome, Ma. Thank you for joining us today.
Thank you very much, Juliana. Could you just give me 5 minutes, please?
Okay, Ma. That's fine. Okay, so while we are waiting for Mrs. Chinasa for about 5 minutes, let's just take the presentation from Team 1. Let me know if Team 1 is ready. Let's use this 5 minutes for our presentation while we wait for her. So it's Tom here. Let me know who is presenting in his group. Which of the team is ready here? Team 1, Team 2, Team 3, Team 4, Team 5, Team 6. If you're here and you're presenting for your group, please, you can just start your presentation. Let me see. Rita, what group are you in?
Team 4.
Okay. So are you presenting for your group?
Not the one presenting. He's around.
Okay. Who is that, please?
Ajao.
Good.
Sorry.
Good evening. Yes, I'm doing presenting for. I just
go ahead. So we're hearing from Temitayo now, right?
No. Group 4, Ajao Moment Temitayo.
Okay, Ajao, please continue.
Okay, let me try and share the screen.
Yes, you can share the screen.
Okay. Can you see my screen, please?
I think it's coming on. Maybe you can start your presentation while we're waiting. Okay. Yeah, I can see your screen, but I can see like the pack of cards and all. Do we have any other team that is ready while Majao tries to solve the current technical issue she's having?
I'm actually ready if we want to go.
Okay, so let's just listen to Mrs. Chinasa.
Okay. If you will give me a minute, let me share my screen.
Okay, ma.
Oh, someone else is sharing screen, so I can't share.
Stop sharing your screen. Few moments. Okay, ma.
Okay, can I proceed?
Yes.
Okay. Can you see the screen?
Yes, ma.
Okay. Okay. So good evening, everybody. And thank you for the opportunity to share just a few words with you on trade secrets and confidential information this evening. I just have about 5 or 6 slides, so don't be afraid. I'm not going to spend the whole day. I told Juliana that I'm going to take just about 10 or 15 minutes because I have seen your presentations, interesting presentations, and yeah, I guess we'll be able to discuss further, once we start. So my topic today is trade secrets and confidential information. The outline is just this basically. We'll talk about what trade secrets are and what confidential information refers to, conditions for protection, types of information protected as trade secrets, protection and enforcement of trade secrets, and then we will conclude. Like I said, I saw your presentations and there are lots of interesting examples there. So I guess when we talk, we can talk more about the practical side of things. But my aim at this point is to give a general idea of what trade secrets are and what confidential information refers to. So quickly, trade secrets and confidential information, intellectual property rights, they are intellectual property rights on confidential information which may be sold or licensed. I just quoted from the World Intellectual Property Organization's definition of what a trade secret is or what trade secrets are. They said it's intellectual property rights on confidential information which may be sold or licensed. And from that definition, you can see that, first of all, trade secrets is a type of IP rights, okay? So if you're wondering why are we discussing trade secrets in this event, it's because it's a type of IP rights. So just as you have trademarks, geographical indications, patents, designs, and so on, trade secrets and confidential information can actually be an IP right. Some other people call it know-how, but it depends on how you want to look at it. So this is a definition from WIPO, and WIPO also says that it's so important because it can be sold, it can be licensed. So in other words, you can profit from it. So beyond using your trade secrets for your own good, you can also authorize the use of it for a fee. It is also information that is not generally known to the public. I underlined some words which I think are critical to the understanding of what trade secrets and confidential information refers to, okay? So it's not generally known to the public. It confers some economic benefit on its holder, and the holder takes reasonable efforts to keep it secret. So the point to note here is that if there's information that is generally known, you cannot claim that it is a trade secret. If they say that, oh, you want to make, how to make a Zobo drink is you buy the Zobo leaves, soak it and boil hot water or spoil it in hot water, put sugar, sieve it, this and that, and all that. And you start making it and selling, and someone else starts doing the same thing. You say, no, that's my trade secret. People are going to laugh at you because it's information that is generally known, okay, to the public. It's not, it's different from saying, oh, you went into the R&D, went into the R&D lab and you're able to come up with a cure for COVID. Then that's different because not everybody knows anything about, the cure. In fact, there is no cure for COVID at present. We're still talking about vaccinations and all of that. It confers some economic benefit on its holder. So if you have some information and there's no economic benefit attached to it, you cannot claim that it's a trade secret. So it has to be in the context of commercial business or a commercial enterprise. What that simply means is that there has to be some level of economic benefits, money in layman's terms, that you get from the trade secret that you have. And then you have taken reasonable efforts to maintain its secrecy. What that simply means again is that whatever information you're talking about or you're dealing with it's top secret, like like the picture I used there says. It's not information that is just anywhere and you don't even bother. So for instance, you enter some offices and you see maybe some schedules that is pasted on their walls and things like that. You cannot wake up tomorrow and say, oh, no, that's my office's confidential information, because you have placed it in a conspicuous place where anyone can, approach and see it. So essentially, any information which an enterprise, gives an enterprise a competitive edge in the market is said to be your trade secret. And the TRIPS, which is the commercial and trade related aspects of intellectual property rights, basically gives or provides, certain things. I've talked about them already, but certain things that you need to have before you can say that you have created something that is worthy of protection under trade secret. First of all, it must be secret, like I said, not generally known, not easily accessible, to the circles that will normally deal with that kind of information. So even if it's known to another, this is getting a bit technical, and it's based on, again, decided cases and all of that. It's different if you say, oh, people know about it. Maybe people in China know about this particular thing. There's this leaf, how they have all sorts of, beautiful leaves and herbs that could cure things or help them in certain, areas of health. And you say, oh, people in China know about this thing. However, people in Africa have never heard about it. And then one company now gets up and starts using that leaf to manufacture a particular kind of food or, drug or something like that. To that company, it can be regarded as a trade secret because it's not generally known in that circle. Okay, and then it's or even if it is known, it's known to just a limited few, typically people within your organization and all that. It must have, again, the second condition is that it must have commercial value because it's a secret. So the commercial value should emanate from the fact that it is secret. Because you have kept it secret, people don't know about it, then it has commercial value. And then you must have taken reasonable steps to protect it. So when people go to all sorts, there's some encryption, some confidentiality agreements, some people would hide certain pieces of information in the safe. Not everybody can access it, and so on and so forth. Those are some of the steps or conditions for protection as trade secret. And then the next thing you ask or wonder is, what sort of information can we protect as trade secret? Beyond the, just talking about the semantics and all that, what exactly can be your trade secret? And, there are several things, but I've just tried to put down three major, categorize them into three major things. The first thing is technical information. Technical information would involve things that have to do with your expertise, your know-how, like I talked about know-how initially. What are those things that set you apart? Let's say the mechanical processes that you have, the way you do things, the way the patterns that you use, and so on and so forth. Those things that are different, the processes, and all that different from what other people know how to do. That's your technical information. So for instance, if you're using like a law firm scenario or situation, how you write your opinions or the kind of advice that you give to clients, the sort of things you go through, the knowledge base that you have, you know, and for me, I'm really big on this because you can be in a place and do work and all that. This technical information is the most important thing because it's something that is kind of like your head knowledge, what you have in your head that no one can take away from you. Those are the kind of things that are protected under trade secret because this is what sets you apart. You know, then commercial information, if people have like marketing plans, business plan, you know, some people can, and I know someone who did a research on all the journals that have been published in Nigeria, all the trademark journals, for instance, have been published in Nigeria since inception, and use that to, you know, map out some strategic plans on how to go about marketing and things like that. All of those things are commercial information. You know, when people start saying, oh, which group of people typically buy bread, and at what point of the day do they buy bread? You know, you start strategizing, you know, and all of that. That's commercial information, you know, or a combination of information. You know, so it could be a combination of technical and commercial information. It could also be a combination of information that is readily available in the public domain. What that simply means is that it's not information that doesn't, so you have, using the example I gave of the sobo drink again, you know that if you boil sobo leaves with hot water, you know, you're able to bring out and sieve it, you can get the sobo juice and you put sugar and all that. Somebody somewhere else now knows that, oh, if you put ginger in sobo, it's going to do this, do that. It has so and so curative effect. And I mean, these are things that are known differently. And then you now pack all of those things. There's a particular ingredient that cures ulcer, there's a particular ingredient that helps you grow bigger, and you put all of them in your sobo drink. Even though you know, on their own, independently, they are all, you know, information that are in the public domain. The fact that you have combined them together to produce a product, that's a combination of information. You can also get, you know, trade secret protection for them. But then I will just quickly quote that whilst you can't register trade secret, if you go to register trade secret, you're not talking about things like patents, designs, and the rest of them. It's important to note that information acquired independently, or for instance, through reverse engineering, you know, you cannot come and claim that, oh, no, you're stealing my trade secret because of that. Because again, remember what we talked about, for it to be known as trade secret, it has to be secret. You should have taken steps to protect it, you know? And so what that also means that trade secret may not be the best form of protection for all types of products or services. There might be some products or services that you have that trade secret protection will be the best protection you can possibly have. But then there are some things that are not. So for instance, if you talk about pharmaceuticals, okay? For pharmaceuticals, trade secret protection may not be the best because you know that if you get a product, a drug, and you know you sell it, people can take it into the lab, reverse engineer, you know, break down the component parts and all of that, and find out what the constituent ingredients are, the active ingredients, and all that, and also come up with another drug, a similar drug. And because it's an independent process and all that, you cannot go and challenge anybody and say, oh, no, you are reverse engineering my product, or you have, you know, you've stolen my trade secret or something like that, okay? So the trick in businesses and in commercial enterprises is to note what sort of IP protection you need to get at every point in time, and whether you should go with trade secret or a patent or trademark and, you know, and so on, you know, depending on what your business objectives are. So I think this is almost my final slide, where I talk about the protection, the actual protection or enforcement of trade secrets, okay? So generally, and what most people know is that, you know, trade secrets are protected through agreements, typically confidentiality and non-disclosure agreements. For me, this is not always foolproof, but I mean, it's a start, okay? I mean, I'm talking based on experience because sometimes people enter into these agreements and I mean, let's not go there for now, but it's a start that you have before you disclose any important, you know, trade secret. You enter into an agreement with the other party where the other party would undertake not to disclose or to, you know, use, you know, or circumvent you and all of that using the information that she has gathered from you, okay? There are also things like employment agreements and policies, which organizations typically have. So in your employment agreement, you can include clauses, you know, that would state that any information obtained during the course of employment and all whatnot cannot be used except as authorized by the organization, things like that. There are so many clauses you could draft in that line. And then policies. A lot of organizations have employment policies, where they clearly state how information in the organization should be used, who has access to what information. There are different levels of access. Not everybody can access certain sensitive information, and if you access it, then you need to answer to a query or explain how you got access to such information and all of that. Okay, so there are different policies organizations could have in this regard. And then there's technology, the use of encryption, artificial intelligence, and the rest of them. People using all sorts of software to ensure that you can't access certain things, or even there are things that people do so that even, particularly now in the age of remote working, people can't access, use certain laptops outside the office environment. People can't access certain files. Some files are encrypted, some are just for those who are on a need-to-know basis, and so on and so forth. And obviously, what we talked about, the TRIPS agreement, section 39 that we had earlier mentioned. Now, because Nigeria is a signatory to the TRIPS, even though it hasn't been domesticated as law as required under our constitution, it still has some level of persuasive value, and depending on if there's any allegation of infringement and all of that, it could be pleaded. Okay. So for me, this is just like in a nutshell, all about trade secrets, what it means, it's information that is confidential, it's not generally known, and steps have been taken, deliberate steps have been taken to have it to keep it secret. Sorry. There are ways to enforce it, like we talked about, confidentiality agreements, policies, and things like that, technology, and so on and so forth. And so we'll look at some examples, even though, like I said, there are already, from your presentation, some of these examples have popped up already. Well-known products protected using trade secrets. And at this point, I will need someone to answer a question. Who knows, or answer some questions? Who knows the ingredients of Coca-Cola? Hope I haven't been talking to myself.
Raising up his hand.
The trade secrets for Coca-Cola.
Sorry, I didn't hear that.
I don't think anybody knows their secrets because it's a top secret. It's a trade secret.
Okay, exactly. I agree with you, and that's part of why Coca-Cola has managed to maintain its, its market primacy up to this point. Why do you think they use trade secret protection? Anyone?
Hello. Yes, ma'am. I think it's because it is really valuable, and they don't want all people to start using their ideas. I mean, there have been other similar products in the markets, but none of them have been exactly like that.
Okay, great, thank you. Any other person?
Yeah. Good evening, ma'am.
Good evening.
I think it's to protect the product from competition.
In what way?
From other companies who do the same transaction, who produce the same, who are all in the same trade with them. So it's a kind of protection from competitors.
Thank you very much. I mean, you guys are right. It's I mean, even though it's a risk, because if anybody should be able to reverse engineer what is in it, or maybe somehow, I don't know how they've managed to protect it so far. There are all sorts of myths. I've heard things about, that at every particular point in time, there are only 2 people in the world that know what the recipe is, and those people never meet each other. They don't enter the same flight and things like that. We don't know how true that is, but yeah, suffice it to say that somehow they've managed to maintain this market share because nobody knows what it is. So from generation to generation, it's like their secret weapon. you know. Same thing for the recipe for KFC and all that, and so many other examples. You know, so and then when you think about it also, why not patent protection? You know, what if Coca-Cola said, oh, let's get some patent protection for this wonderful, wonderful drink, you know, invention. They could have done that so many years ago, you know, and all that. But they didn't, because it would have expired after like 20 years and gone into the public domain, you see, and then everybody to be free for all for everybody. Again, some people argue that, well, recipes are protected under copyright and so on. But anyway, I want to stop here and then listen to you. If you have any questions and all that, I'm happy to answer. So thank you for listening to me.
Thank you very much, Ma, and congratulations on your induction. You're looking beautiful. Congrats. Okay, so for your questions, let's just start. So we'll just take one question each. Once you ask your question, the next person will ask their question so that she can answer them before she leaves. Or should we just take like 5 questions since you're supposed to leave by 5?
I'm happy to take questions.
Okay. Okay, Ma. So let's hear from Divine. You can unmute yourself. Divine, Humomot, or Ayodele. Okay, Blessed, you can ask your question.
Good evening, man. Good evening, everyone. Good evening, man. Good evening, everyone.
Good evening.
Thank you very much for the audience, man. In an organization that is as big as Coca-Cola now, we know for years now, trade secrets have been the reason why they've been able to keep the recipe behind Coca-Cola a secret. The question is now, Coca-Cola now is such a big organization with hundreds, probably with thousands of staff. So how can one enforce these confidential agreements, clauses, and policies you've been mentioned of earlier?
Okay, thank you very much. Let us take the question from another person. Let us take another question, please. Busola, you can unmute yourself. If you have a question, just unmute yourself and ask your question so that we can be fast.
Okay. Good evening, everyone. My question is, according to my research, I realized that we don't really have any express legislation protecting or law protecting trade secrets in Nigeria. So I want to confirm if that is right or there's an express law protecting trade secrets or confidential information. Thank you.
Thank you. Do we have any other person that has a question?
Yes, ma'am. I have a question. Okay, my question is about confidential information. I mean, trade secret and geographical identification. I feel like some of these things that we call GIs, I think they should be protected by trade secrets. I know that they are between a large number of people, but is there a way we can protect them with trade secrets rather than GI?
Okay, thank you. Do we have any other question?
I have a question.
Okay.
Yes, my question is, it's called trade secret. So what if...
I'm sorry, I can't hear you.
Okay, can you hear me now?
No.
Hello?
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 Go ahead, please.
You can go ahead.
Yes. My question is, since it's called trade secret, right? Are there some secrets that, for instance, there's some things that may not be secret anymore? Do they fall under the protection of trade secret? So where do we draw the line as to information that's already available in the market, owing to the internet and information Because, for instance, it was easy for Coca-Cola or for KFC back in the days to protect their trade secrets. What happens to information that is now, more or less like public knowledge? Can those things still follow that trade secret if someone has found a way to do something?
Sorry, Samuel. Hello, Samuel.
Yes, ma, can you hear me?
You can type your question, Samuel, because I think that your network is...
So sorry, I didn't get half of what you said. You can type it in the comment section.
Okay. Do you have any more questions?
Yeah.
Okay.
Yeah. Is it compulsory? I painted my trade secret.
Okay.
Okay. Do we have any other question?
Yes, I have a question.
Okay.
My question is, in Nigeria, what are the requirements you have to do in order to protect that secret of yours, so that when there is a copy or an infringement of it, you can sue in court? So that's the question.
Okay. Might have a...
Okay.
Okay, I want to know to what extent are these protected? For instance, using the recipe for Coca-Cola as an example, now we know that it's a secret in the organization and everything. How do we know that there are substances inside that are not harmful to individuals? Maybe not immediately, but in the long run. There have been many that the contents of Coke are not healthy and the rest. So are we going to protect an organization's secret at the detriment of maybe health or security or things like that? How far does the protection of this trade secret? Thank you, ma'am.
Thank you. Do we have any more questions?
Yes, please. Yeah, good evening, everyone. Yeah, my question. Thank you. One of the means of protecting trade secrets by organizations or employers is by way of executing confidentiality agreements. In most confidentiality agreements, it is usually drafted that the confidential obligation of the party concerned shall survive termination of the contract, and it shall remain in force for a period of time, which could be as agreed by parties 2 or 3 years. My question now is that, can an employer or an organization take action against an employee or a contractor that discloses this trade secret after the period of time as stated in the agreement has elapsed?
Okay, thank you, Rita. Do we have any more questions?
Yes, I have a question. Good afternoon, everybody. Hello?
Yes, go ahead.
Okay, my question is, can a trade secret be sold? And if yes, even after selling it, does the person still need to protect it? Even after, does the buyer need to protect it after buying it from the seller, if it's possible that the trade secret can be sold? Do you get my question?
Yes. Okay, someone is asking, what is the duration of the trade secret? And then I think someone has also typed his question in the chat box. So his question is, with the availability of information at the push of a button in this era of technology, how do we draw the find a trade secret? So I guess everybody has asked their question. So maybe we'll just move to answers. Thank you, Ma.
Okay. Thank you so much for all these questions. It's encouraging because it shows that you were listening and or at least you've done some research on this prior to now. To quickly run through, I tried to take some notes. I don't know if I got everything, but I tried to get as many of the questions as I could. So Juliana, I don't know if you took notes as well. If there's, or anyway, anybody listening, if there's any question I don't answer, please just flag it quickly. Is there any trade secret law in Nigeria? The answer is no. Okay, there's no one law, there's no legislation, there's no trade secret legislation in Nigeria as yet. In some other jurisdictions, the US, EU, and the rest of them, they have trade secret legislation, but we don't have one for now. And that's why I kept on talking about the TRIPS, agreement on trade-related aspects of intellectual property, rights, because it's a treaty, it's a WTO treaty, but then it's a treaty that, also has provision for trade secret. And because Nigeria is a signatory, like I mentioned, it has persuasive effect in Nigeria. Someone said, how does Coca-Cola do it with lots of staff and all that? You know what I said? I said that you have to take deliberate steps. You have to go over and above to keep your secret. If it's that important to you, because let's look at it this way, intellectual property rights, can be protected under the law. You're able to register certain types of intellectual property rights. You can register your patent, you can register your trademark, your design, and so on and so forth. If you choose not to register it, then you have told yourself that, I'm going to protect this as a trade secret. The idea behind registering, for instance, a patent is that you disclose information about your products or your service or whatever it is that you have, your invention, right? In exchange for protection by the government. So you disclose what you've done and the government protects you for a specified or a specific period of time, And then after that, the only thing is that because the law also recognizes the fact that if this invention is new, nice, useful and everything, it will also be good for other people to benefit from it. And that's why it's a time-limited period after which it falls into the public domain. But for that period that you've disclosed and you are protected, trade secret, on the other hand, is that you choose not to disclose, so you have to take, the responsibility is on you to take steps to protect. And that's why I talked about things like, using technology, encryption, and so on and so forth, having a safe where they deposit certain things people can't go. There's only people disclosing information to people that only they're just on a need-to-know basis, and things like that. I don't know how Coca-Cola does it because I don't work in Coca-Cola. However, they must have taken definite steps, deliberate steps, to keep people from knowing. Perhaps the information is not open to everybody, only the top management level and things like that, okay? Someone talked about protecting GIs as trade secrets. Now, for me, I would say that it's a bit tricky. Whilst, your GI is a secret known to a certain area, a geographical location and all of that. Trade secret is typically found it's secret, but it's not always secret per se. Because for instance, when we talk about the easy example we give is like wines. You get the plants from a certain part of the world. The soil has certain qualities or qualifications, right, that make the berries or fruits or whatever that you use for the wine to taste in a particular way. It undergoes certain, and then it is based on the climate, based on the soil, based on, so many things, the cultural, understanding of the people and how they, groom their plants and all of that. So even if you might know about it, but just because you're not in that location, I don't know if you see the difference. Okay, it's something, it could be a secret, like you talk about health, different plants and how they can have some health benefits and all of that. So to that extent, it could be a secret known to a particular, geographical location or a certain people or culture. However, in the case of geographical location, it's just that the product emanates from that. It doesn't mean that you cannot do it. So you can be in America and make an Adire cloth, for instance. Doesn't mean that you are from Nigeria or that it necessarily emanated from there. No, we have Gary that is made in China. We talked about this the last time. Doesn't mean that, okay, it's their GI, no. So it's a secret that people know, but then you know that you can make Gary from cassava. However, it's not necessarily your GI. I don't know if that demarcation is clear. Then is it compulsory to have a trade secret or to register a trade secret? The answer is no. It depends on you. And that's when I talked about you choosing the best form of IP protection that you have. And I gave the example of the pharmaceuticals. You know, it may not be in your best interest to use trade secrets for pharmaceuticals or for technological products. A lot of, you know, arguments about people carrying products from, you know, from the North America and all of that, and going to Asia and reverse engineering and coming up with some of their own products. And these are the arguments, right? It's not compulsory, but you need to be certain what, as a business owner or as a legal advisor to a business, which one is the best protection, you know, possible for them. Then there's the issue of health risk, you know, trade secrets versus health risk, which is a very valid concern, to be honest. And again, depending on the product. But I would just quickly say that, you know, we have this trade secret law, which is in the commercial realm, but we also have the regulatory aspects of it. And so, for instance, in Nigeria, we have NAFDAC that regulates every food and drug, you know, that is imported, manufactured, distributed, sold, advertised, and so on in the country. And before any product is put out there for sale, NAFDAC would, you know, verify. They have what they call laboratory analysis, where they look through the content of the product and all that. And it's only upon approval that you would you'll be able to, you know, be able to sell. And, you know, and that's part of why you have all these arguments about, oh, the Coke in Nigeria doesn't taste the same as the Coke in America. It doesn't taste the same as this and all that. Because country by country, the relevant regulatory authority would look at these products and, you know, certify them, you know, fit or not for consumption. Again, SON does that for some other products that are not food and drugs. Can you go after someone after the time that is specified in your agreement? You know, if you're in a confidentiality or non-disclosure agreement, to say, oh, this agreement would endure for the next 7 years, blah, 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 and all that. So after 7 years, can you go after the person, you know, if the person discloses? The answer is, of course not. I mean, well, you can go after if you like, but whether you succeed is another thing. Of course not, because it's an agreement. A contract is a contract. As long as both of you have agreed to a contract and agreed to a timeline, when that timeline elapses, you're not under any obligation under that contract, and no one can sue you successfully for breach of contract. Okay? Can your trade secret be sold? By all means, yes. Remember, we said that it has economic value, you know, and if you look at the definition that I gave from WIPO, they said you can sell or license it. So you can decide to sell your trade secret, you can decide to license it. Again, subject to whatever terms, you know, of the agreement between you and the party. I mean, and then if, for instance, if they sell it, it depends on the person that they buy. If the buyer decides that he wants to make it no more a trade secret, it's up to the buyer. If the buyer decides that he wants to still keep it secret, I'm sure that there would have been an agreement between the parties saying that even though you're selling this to me, you're not going to disclose to a third party, and so on and so forth. Duration for trade secret, as long as you can keep it secret. Trade secret can last forever, and a case in point is what we have been talking about, Coca-Cola. Then where do you draw the line? Okay, this is from Samuel, when you talk about the availability of information and push of reports in this era of technology. How do we draw the demarcation on what is defined as trade secret? So if it's, you know, remember I said that there are exceptions to, you know, this thing about trade secret. And it's about, you know, if you have independently come up with something, nobody can come and tell you, no, you stole my idea, or you took this, or you took that. If you have taken steps to keep your secret secret, then it shouldn't have fallen into the wrong hands in the first place. But then if somebody independently comes up with something and you start claiming, oh no, you copied my idea, whether you prove it now, it's not just a matter of just claiming that someone is, you know, someone is infringing on your rights. There are issues of unfair competition, you know, breach of contract, and all of that. Those are ways you could go after someone who you believe is infringing on your trade secret rights. So for instance, person has breached this contract, you sue the person for breach of contract, or unfair competition. Maybe someone leaves your employment and goes to another employment and starts using your secrets and all of that. You can sue. Those things are there. But then if it's someone that independently comes up with something and can show that it was independently, come up with, and for instance, person did not work for you, doesn't know anything about you, has never stepped into your office, doesn't know your facility, you now say, oh no, you're using my trade secret. It's different. But it's a different thing if it's someone that was working for you. All of a sudden here he's working for Mr. A or B, and then you're using your products or using your secret, and you say, no, that's my trade secret. Now that's also a bit technical, and that's why, when we advise clients, we make sure that we tell them, if you don't have this agreement, you need to put relevant clauses in your agreement, because like I said, know-how is know-how. What you know in your head is what you know in your head. I work for Uwanna and Ighodalo today. I've worked for Uwanna and Ighodalo for almost 10 years now. If I walk out the door, right, there are certain things I know that are in my head that, it would reflect in the quality of work I would give wherever I go. It reflects in how I relate to people and all of that. Okay? You cannot come and take it away from me because it's my know-how, it's me. You cannot come and claim, oh no, she's using what we taught her, or no, But it's a different thing if I walk out of Uwanna and Ighodalo and then I take their client list and start seeking it up, using it. Remember we talked about commercial information, or I would start taking the opinions they had issued and start giving it to people. And honestly, I've worked for 2 or 3 other I've worked for 2 other law firms before working in Uwanna and Ighodalo. My boss is here. I did not take their work and go and give to the new firm. Do you understand? It's about how you handle it, but what you know in your head is what you know, and no one can take it away from you. Sorry about that. I think I've answered most of the questions. I don't know if there's any question I left out.
I think you've touched almost everything, Ma, and you've touched them excellently well. Thank you so much, Ma. Thank you so much for the knowledge shared and for the practicality of your explanation. So we also have Mrs. Uche here and Mr. Folarin. So I think that it would be good for them to also just talk about this topic in some minutes. Mrs. Uche, please, would like to hear from you on this topic, Ma.
Hi, Juliana, thank you. And you too, Chinasa. Chinasa says she didn't take anything from our firm. Maybe you bring your bundle of work. Let me look at it and see if you're speaking the truth. I'm kidding. I just want to break the ice. Fantastic presentation, Chinasa. Well done. Yeah. So there's little I could add to all she said, except to just in a nutshell say that 3 can keep a secret if only 2 of them are dead. This is a quote from Benjamin Franklin. So it's very difficult to get people to keep a secret, especially staff. Employees are the easiest leaks. So, it's tough, but then you need to take some steps. If it's of value to you, you need to take steps, because if it ceases to be a secret, it loses value. The only thing that gave it value is secrecy. So you need to really maintain it. Trade secrets, people think it's new, but it's actually the oldest form of intellectual property. And the information, like Chinasa mentioned, they are not generally known. And then it has competitive value, i.e. secret source. It's not because somebody has copied what you're doing, they copied your secret, but good management of trade secrets is often that you keep the secrets different tranches in different places. So you can never get the complete secret. If you're really a good manager of trade secrets, nobody gets the secret source, except the people that will die with that secret. So it's very important to really know the channel, the people that have it. Otherwise, you have NDAs to protect it so that even if they leave you. But even NDA also has its ups and downs because, for instance, in Silicon Valley, for startups, when they're just starting, they just sign these agreements and then they kind of hold the employees to their commitments not to take the technology to the next company they go to. But that's for a limited period because that law in America is different states apply different rules because of technology, because of the society we are in. Coca-Cola that we often use as an example is over 100 years. So then things like this really count. But now there are young companies, people are competing, people are coming up with ideas. So it's very difficult to hold somebody's intellectual capital and say, if you go, you cannot use, you can use the trade secret, but you can't tell them not to work for. That's why I like the case on PepsiCo that is coming on shortly. That you can't, unless you realize that in the case of PepsiCo, they were able to establish that this guy is key to our secrets, our secret source. If he goes to our competitor, know how, in his sleep, he can say something, he will remember, he will divulge information. Unlike the other case where you can't just give a blanket rule, oh, okay, because don't take our employees, you can't do that, things are changing. So my point is that with big companies, you can maintain the trade secret, but with smaller companies, they don't have the facilities, the structures, to really keep it. So it becomes that, and judges are human beings. So oftentimes they look at both sides, look at what happened in the two cases the team submitted, the PepsiCo and the other case. So judges, they varied. In one case, the plaintiff succeeded. In the other one, the plaintiff lost. So because you need to look at all of this. So we need to look at what is protectable secrets, like raw data, AI algorithms, unannounced product. If, for instance, we often hear from clients, oh, we're coming to launch this product, this drink in Nigeria, you need to register it, because they're careful. They need to register the trademark to make sure, or patent or whatever, to make sure at least they have protection so that nobody else can, because once it's launched and it's put out there in the public, everybody will scout, or if people get a wind that this is what they're trying to do, they can go and register before them in bad faith. So unannounced products are also protectable secrets. Then information on your customers and suppliers. Chinasa mentioned the list of clients, you keep them, and then there are information clients share with you on their intellectual property about them that you don't want it out there, because if it gets out, their competitors will get it. And as you know, IP is the most valued asset anybody could own. So this run into billions of dollars. So by your simple mistake, you let these things out, and then it gets into their competitors, and it's then they will lose value. Then strategic marketing, just a way your financial plan, just a way your operational people do business, just a way they, like in the day of this time of COVID, people are trying to conserve what they have and hold the money to the chest and not spend it. So we are cutting costs. So all of these things are what really makes a company successful. So these are the kind of things they will keep, all those financial plans, all the strategy, all the marketing that you plan to do for the year. Then of course, R&D also. And not only the successful ones, but failures. The people that came up with the vaccine, COVID vaccine, there are some dead ends, there are failures. So these are because you look at them so that when you start again, you do it better. So these are things you have to look at. Then the value of the information, you need to concentrate on what is of most value to you, not everything. So that's why you're calling it trade secret, because it's difficult to maintain. So you must maintain the ones that have the highest value. Because many secrets, especially business data, they degrade over time. With what is happening, there are new inventions, there are new ways of doing business. So over time, the secrets will eventually come out. So just protect what is of immense value to you. Then finally, the risks. So you want to avoid the recruiter's dilemma, because the presenter, the person that is going to present on the PepsiCo also mentioned exactly what happened. These are sort of recruiter's dilemma, because your most intelligent hire might be very dangerous. So you need to be careful. And how do you avoid those ones? although it's the best hire, but you need to really do orientation, let them have the culture of your company, training. Like I mentioned, the employees are the most common source of leaks. It happened to Coca-Cola in those days. So, and a whole lot of them. Big corporations are facing this thing every time, because how do you force people to behave well? They walk through the door, they are good. After a while, especially now things are hard, but then there are ethics. You know, I liked in some cases where the judge or the company, I remember in the Pepsi case, and I think the company that he was going to go to claim that, oh, ethics, so we'll read it and we'll make sure that it doesn't, they can say that they might not follow through. But ethics is good for business, because if it goes out there, I know companies that do that, they don't have respect, but you need to really keep to your word and have respect, because your business partners, even though you're competitors, but that doesn't make you, because you're looking at your economic lens, then you throw away the ethical lens. You can't do that, because to stay in business, also your customers are watching, especially now that everything is online. People want to know and see if you're a good corporate citizen, or you go about stealing people's intellectual property or drafting all kinds of NDAs to hold your employees from, you know, succeeding once they leave you. So all of those are things you look at, and then of course, finally, termination. If you you want to terminate, it's always good to lock the systems, because that's when people really copy all your stuff. And then there's what is called exit interview. You're not fighting, so engage them and discuss with them. And then I know in my firm, usually we have alumni, so it's always like people that work in our firm, that are friends of the firm. We invite them whenever we do things. It's always good to maintain a good relationship, because if you have a good relationship with somebody, they will not go out of their way to hurt you unless if they're intrinsically bad people. So for that, I will stop here and see if you have any questions. Thank you for having me.
Thank you very much. Thank you so much for sharing. Thank you for adding to what has been shared already. Amazing input, amazing knowledge shared, and you are looking beautiful as ever.
Thank you.
Always.
Thank you. Thank you so much.
Thank you. So let's quickly move to Mr. Folari. I know that you have something to add, so it's very important that we hear from him too.
Hi, Juliana. Can you hear me?
Yes, sir.
Okay. Good evening, and thank you very much. Fantastic conversation. I should say well done to Ms. Chinasa for that very interesting, for the interesting presentation. You know, I think it was very well put together, well researched, and fantastic stuff. I should also say a big hello and well done to our madam at the top, Ms. Okocha, for her insights. I think between the two of them, they practically said everything. So there's not so much to add.
Thank you.
I'll just say, I think in practice, just one or 2 points. NDAs, we find that in practice, NDAs tend to be, usually you find that the people who try to claim or who try to enforce an NDA in, let me look for a way to reframe this now. In practice, you find that the people who are willing to protect a trade secret are often in the balance of when you look at the balance of power, you know, in those types of relationships, you find that the balance of power is often against the person who wants to secure the protection of who wants to protect a trade secret. And what tends to happen is, let's say, for example, let me give a scenario. Somebody walks to a company with a proposal and says, oh, I would like to propose X, Y, and Z business venture or whatever to you. And but as a preliminary to that, I would need you to sign this NDA. You know, you find that most companies are not willing to sign. Most individuals, most venture capitalists will not sign and will not sign an NDA, especially when they're not certain as to the content of the proposal. And the reason is because, you know, it creates some kind of trust obligation on both sides, such that even if they had received or they were working on a proposal in-house that was similar to what is being proposed by this person pitching, it would appear as though, you know, that person is using the information that, you know, as if the company is using the information that this person pitched to them. A very recent example, though I'm not a fan of this business, people do these, they write business proposals and then take it to Copyright Commission for the notification. But there was, I think the media, there was news about a case involving Guarantee Trust Bank. Guarantee Trust Bank is being sued by somebody who pitched some kind of marketplace to them. And then of course, GTB didn't run with that idea, but ultimately they ended up, of course, I think the GT Bank, is it the food marketplace? They ended up coming up with their own concept. And this person is suing for upwards of 500 million naira that GTB stole her concept or his concept or you know, whatever. So in that kind of situation, you know, you don't know what the person who is coming to pitch is going to pitch, you know, and signing an NDA may bind one to all sorts of obligations. So you find that in practice, companies, venture capitalists, investors tend to shy away from transactions where an NDA is required to be signed before any kind of disclosure is made. Whether how to go about it or how to ensure that, you know, the balance of power is balanced, or this situation is balanced, is an interesting one. Whether the answer is legislation, I'm not so sure, you know, but that's an interesting point to note. I think the other thing I was going to mention was, I'm not sure whether trade secrets are a thing in Nigeria. And I say that tongue in cheek, but for the simple reason that it's not a statutory, there's no statutory provision that provides for this intellectual property rights. I know Chinasa mentioned TRIPS. TRIPS, yes, is a minimum set of standards, but the fact that, again, one will argue our laws, because it's a set of standards that you have to model your laws against, we still don't have the provisions, the local provisions, to match any TRIPS article on trade secrets. So that's a question that's up in the air. One can also argue that it's part of the common law. I think that's also easily arguable. I think there's a strong argument in the space of the constitutional right to privacy. So there's a strong argument there, you know, and I find it also very interesting when referring to trade secrets as an intellectual property right. You know, in this space, I think a lot of people tend to we tend to confuse the trade secret with the intellectual property, you know, and use the phrases or these terms interchangeably. The idea itself is the intellectual property, and then the trade secret is the right. So in order to enforce the right, that's to either bring an action for misappropriation of the trade secrets, that right must be one that is actionable. It must be a valid cause of action within that jurisdiction. So, I mean, in terms of Nigerian jurisprudence, again, I think the constitutional provision of guarantee of the right to privacy, I think it's section 39 of the 1999 Constitution, will be a very strong basis. But again, I'm a little between and betwixt as to whether trade secrets should be considered to be some kind of intellectual property rights. You know, yes, the subject matter is intellectual property, but just as Chinasa mentioned in her presentation, when talking about what types of intellectual property or what types of property or intellectual work can be protected by trade secrets, it can vary from something as simple as a recipe you know, to the formula for X, Y, and Z. And we know that recipes, there's no other form of protection that recipes can be subjected to, generally speaking now, under the copyrights, trademarks, patents, industrial designs, format of intellectual and industrial property. You know, unless you publish a book of recipes, in which case it will be protected as a literary work. So I think that's an interesting, I mean, that's something to just agitate the mind. Then the banter between Ms. Nwakocha and Chinasa also brought to mind another area of an interesting aspect to this conversation, and that has to do with trade secrets in employment. I think our employment jurisprudence kind of draws a line between there's somewhere, you know, a line in the sand somewhere between what we may call an enforcement of, let's say, a non-disclosure clause or a requirement that a secret should be kept maybe by an employee, and restraint of trade. And we find that the Nigerian courts tend to side, or they tend to err on the side of the employee, in the sense that Nigerian courts tend to, Nigerian courts do not favorably look at restraint of trade clauses, especially when you have a clause that may be aimed at protecting certain types of information, but all information, just as Mr. Nwakocha said, all information, or the value of information changes per time. And so information that may have been valuable 10 years ago may not be valuable today. And so the courts tend to treat clauses that, you know, shackle ex-employees or former employees or exiting employees as restraint of trade provisions or clauses. And the courts, from our jurisprudence, the courts tend to narrowly construe these clauses. So I think that's also one area that, you know, that just pops off that comes to my mind. You know, and so we see that the concept of trade secrets spans several areas of law. We're talking constitutional law as far as Nigeria is concerned. We're talking contract law, generally speaking. We're also talking about employer-employee relations. So there's a labor law component to it. And of course, there are, I'm sure, several other moral and ethical components. But again, fantastic presentation. Well done. Thanks, Juliana, for having me. Network bumped me off last week, but I'm glad to be here today.
Thank you very much. Thank you for also adding to the conversation. Thank you, sir. I think that we'll just move straight to the presentation. So we have 6 presentations for today. So we grouped them into 3s, and then one person will be presenting for each team. So I asked them to just get one piece on trade secret and confidential information and present on it. So for team 1, who is presenting for team 1?
I'm presenting for team 1.
Go ahead.
Okay. Good evening, everyone. I'm here to talk about the case on trade secrets and confidential information. So I'll be sharing my screen. Okay. I'm coming. Don't know if you can see. Please, can you see my screen like this?
Yes.
Okay. So this case is on talks about Andres Commonwealth versus Leventis Motors Limited. It happened in 1973. So in this case, the appellant was sued for a breach of his contract of service as a spare part sales manager, in which he left the company, and after he left the company, about 3 weeks later, he joined a rival company in Apapa. Okay. So according to the clause 6 of the service agreement, the appellant was not for at least a year following the determination of his employment to undertake or carry out a similar business or employment as that of the respondent within a radius of at least 50 miles from any trading station. And within 400 yards of the business premises of Leventon's Motors, there was another company that was called Nigerian Technical Company Ltd, which was also engaged in a similar business. And both companies were competitors, and sometimes they competed for agencies from overseas dealers. And after the appellant joined the rival company, the company he was working for before, which was named Cumulis, served a letter to his new company called Leventon's Motors. And this alerted Leventon's Motors Limited not only of the company's presence in Nigeria, but that it was also working for the company earlier before. So Leventon's Motors Limited sued Cumulis at the High Court of Lagos State for the breach of his agreement of service. As I said earlier, he was asked not to work for any company within a certain radius for at least 1 year. And then the judge reviewed the evidence and they entered judgment for Leventon's Motors and awarded them damages of £1,000. And the new company was dissatisfied with the decision. And then they filed an appeal contending that the clause 6 of the contract of service was too wide and unenforceable. Then the Supreme Court decided that the general law relating to the breach of confidence prohibits ex-employees from using information that is the property of their old employer as they wish. And the Supreme Court affirmed the decision of the trial court. In essence, what this case is talking about is that the Supreme Court was of the opinion that he was not supposed to work for the new company after he had already left his old company. This is because they were rival companies. He had information that can be regarded as confidential information. And as a result of that, there was a breach of confidence. And the Supreme Court was of the opinion that the decision of the lower court that the former company should be paid £1,000 should remain like that. So in relation to what we've been taught today, we can see that, as Mr. Folari said, it is in connection with restraint of trade also, that trade secret and restraint of trade actually looks similar, looking at this case. So he had trade secrets, or he had knowledge about the information that could also be beneficial to the new company. As a result of that, the court held that he was going to be liable to pay certain amounts because ex-employees should actually not use the property of their old employer as they wish. So that's what the case is all about.
Thank you very much, Sola.
Thank you.
Thank you. So let's go to team 2. Who is presenting for the second team?
I'm the one presenting, ma'am.
Okay, please continue.
I can share my screen. So time.
If it's not possible to share your screen, you can continue.
Okay, I'm sorry, I tried it before, but I just don't know how to do it now, so I'll just continue with the presentation. So my name is Blessing Shuma, and I'm representing Team 2 for this presentation. And our case is the case of Fakenda Chicken Limited versus Fowler and others, 1986 case. So in this case, Fakenda Chicken Limited had employed Mr. Fowler as a sales manager, and Mr. Fowler had actually suggested a kind of process, a system of doing their business. Drivers would carry the frozen chicken from places to places in a van that would refrigerate those chickens. And the company, Fakenda Chicken Limited, accepted this idea, and it was established in the company. After some time, Mr. Fakenda left the company and established a business that was similar to that of his previous employee. when he did that, he also employed 8 drivers from the previous employee. And these drivers, because of they understood the nature of the business at the former company, they knew the addresses of the customers and their names and whatsoever. So the former company, that's Bakenda Chicken Limited, brought an action against Mr. Fowler and those drivers, stating that they did not have the right to actually use the information they had obtained working for their previous employee. So, and they claimed damages and breaches of the respective contract of employment and breach of confidence. Now, the court held that the information gained by an employee in the course of his employment fell into 3 categories. Number 1, information which was readily accessible to the public and could not be termed trade secret. Number 2, confidential information which he could not use or disclose during his employment without breaching his duty of fidelity to his employer, but which in the absence of an express restrictive covenant, he was at liberty to use either during or after his employment. Then number 3, confidential information that were specific trade secrets, which he was not entitled to use even after his employment. And the court held that the category of information which the drivers and Mr. Fowler used fell under category 2, although they were confidential information, but there was no clause in their contract that restricted them from making use of such information. There was no express clause stating that they were restricted from using such information after their employment with that particular employee has been terminated. So the court actually ruled in the favor of the defendant, and the plaintiff's action was dismissed. Now, the plaintiff also went on an appeal, and it was held also on that appeal that in the absence of express terms, no term was implied which imposed upon an employee an obligation binding upon him after his employment had ceased to use or disclose confidential information short of a trade secret. So in essence, if it's not a trade secret, if it's just an ordinary confidential information, and there's no express term in your contract of employment forbidding or restricting your those you have employed from, divulging the information after their employment have elapsed, it does not, they cannot be sued, an action cannot be brought against them for such a case. So that's the end of the presentation. Thank you very much.
Thank you very much, Blessing. That's an interesting case, and it's so sad. Thank you, Blessing. So for team 3, who will be making the presentation? Team 3. Okay, if they are not here, then we'll go to team 4.
Okay, I'm ready. Team 3, I'm ready. Bye.
You can proceed, Divine.
Okay. Good evening, everyone. I don't know if I can help with the slide. I don't know how I can get it.
Please, can you leave where you are? It's a nice.
So I think I'm coming to talk. Okay. Is it better off now?
You can go.
Okay. So for team 3, we looked at the PepsiCo INC case versus William Redmond and Quaker. That's the Quaker Oats company. So basically, the facts of this case laid against the backdrop of fierce beverage industry competition between Quaker and PepsiCo in the production, more especially in the production of sports drinks and new age drinks. So William Redmond, who worked for PepsiCo in the North America division of Pepsi, from 1984 to 1994, rose to the ranks of the general manager in its California branch, the California business unit of the company. So Donald Buzik, who left PepsiCo at the beginning of 1994, the same year that William Redmond was promoted, became the head of Quaker's Gatorade division. That means he became the head of division wherein both Quaker and Pepsi are in fierce competition. So he became the head, and at some point he contacted Redmond to join him at Quaker. So sometime in November, Redmond met the chief executive officer of PepsiCo and told her that he had decided to accept Quaker's offer and then resigning from PepsiCo. So at that point, PepsiCo had to file a diversity suit in November of that 1994, seeking a temporary restraining order to enjoin Redmond from assuming his duties at Quaker and to prevent him from disclosing trade secrets or confidential information to his new employer. So it was quite an interesting one, with several arguments. So at some the court held that PepsiCo argued, first of all, that Redmond would inevitably disclose that information to Quaker in his new position, at which he would have substantial input as to Gatorade and Snapple's pricing costs, managing distribution, systems, products, packaging, and marketing, and to give Quaker an unfair advantage in its upcoming skirmishes with PepsiCo. But Redmond asserted that the integration would be conducted according to the existing plan. That means he won't be bringing anything new to the table. Everything he will be doing is based on what is already existing. So he's just coming to implement them. The district court, however, thought that PepsiCo's position was right, and that by virtue of Redmond's new job, it posed a clear threat of misappropriation of trade secrets and confidential information, and that could enjoin under criminal statutory and common law. So the court emphasized on the district court basically emphasized on Redmond's attitude towards accepting the new job, new role at Quaker. There were more of his attitude because he had some discrepancies in his stories. Some he told them he was just resuming as an operations manager, and some others he told them different stories. But however, the issue before the Court of Appeal was whether or not the district court was right to have concluded that PepsiCo had reasonably, or the that PepsiCo had a reasonable likelihood of success on these various claims of trade secret misappropriation. So that was the issue for determination for the Court of Appeal. So so the court holding this position. The court, however, the Supreme Court of Appeal held the same position as the district court, however, with slight differences in ratio. They paid more attention to the fact that it is unavoidable. It is by virtue of his position at Quaker, it is unavoidable for him not to misappropriate trade secrets. So, in other words, he cannot do without, whether or not he signs an agreement with Quaker to say that he will not give them any illegal information, whether from the previous employer. He cannot avoid that. Whether he says nothing about it to influence his pricing in his new company. So the Court of Appeal affirmed the district court's order enjoining Redmond from assuming his responsibilities as Quaker and also preventing him from disclosing PCMA trade secrets and confidential information. But however, there's this point I want to highlight. In the case of PepsiCo, they made mention of two cases, the Terradine case and the AMPS case. The citation is on the slide. In the Terradine's case, it was more of a competitor luring staff from starting from fellow competitors' company, and the court held that yes, that an allegation that clear that could not operate with Terradine's secrets. They held that Terradine could do without the secrets of the previous company because what he's just bringing to the table is more of his skill. So the court held in both that AMPS and Terradine's case to say that plaintiffs could do nothing more than assert that skilled employees they are taking their skills elsewhere. So all they were fighting for was just trying to prevent their skills and not really proving a point that people had a valuable part to play in competitors' company and as such will be in a position to relate trade secrets. So they could not prove that. They could not prove their point beyond that. So all they could show was that, okay, they had a skill, they are moving, they are viable, he was an operator in our company, also been an operator in our competitor's company. So as a result of that, he released it. But they could not establish one, the trade secret. Two, they could not also establish that they will use anything beyond their skill. For the Pepsi case, we could also tell that by virtue of Redmond's position while he was in Pepsi, he was privy to the agenda for 1995. They already had a plan for 1995 sale, which put them on the edge over their competitors quicker in the market. So they had strategies for sale and pricing and how to get their goods to the final consumers, which he's privy of, which most of those agreements, he also signed. He's also a signatory to them, and he also was also a part of the plan. So by virtue of that, he would deliberately either avoid or to affect his activities quicker, and so put Pepsi under an undue advantage. So that was basically the case for PepsiCo and William Redmond.
Okay. Thank you very much. Thank you very much. So the next presenter, I think that's Uwanna.
Yes. Good evening.
So you're with group what? Group 4 or 5?
I'll be presenting. I want to talk on definition of terms. So let me just talk a little. So trade secret and confidential information are what that seeks to protect know-how and enhance trade. Walter Good defines trade secret as information deriving its value and being known to the public, competitors, and other parties. So the elements essential to maintaining an action for breach of trade secret or confidential information. 1, that information was of confidential nature. 2, that it was communicated in circumstance imparting of confidence, and there was an unauthorized use of the information. So now we're going to the next one, the case. We are using the case of Cocoa versus A.N. Clark Limited. The plaintiff designed a mop engine and sought the cooperation of the defendant in its manufacture. After the plaintiff had disclosed the defendants all the details of the designs and proposals for manufacture, the parties fell out and the defendant decided to manufacture their own engine. The plaintiff alleged that the defendants had deliberately broken when the defendants brought out their own design, which closed injunction to restrain the defendants from misusing information communicated to them in confidence solely for the purpose of the joint venture. The defendant denied that any confidential information had been supplied to them or used by their engine. The court held that of the 3 elements essential to a cause for action of breach of confidence, namely 1, an information was of a confidential nature, 2, that it was communicated in circumstances imparting an obligation of confidence, and 3, that there was an unauthorized use of the information. Only the second condition was satisfied by the plaintiff. That means that it was communicated in circumstances imparting an obligation of confidence. It was also held that, 2, the information was communicated alleging confidence in the expectation that the plaintiff would give monetary reward. Therefore, it was doubtful whether an injunction against using the information was appropriate remedy if a dispute occurred. That the plaintiff had not established a strong prima facie case that the information was confidential in nature or had failed to reveal that the similarities between the original qualities which would amount to confidential information. So it was further held that, unlike the therapy case, interlocutory relief was not appropriate in the present case, as there was no cross-examination of witness on the hearing of the motion. The plaintiff's charge of fraud could not be determined on affidavit evidence, on motion, and
Please let me know if it's my network that has the
engine
issue.
was not in production and did not need the same degree undertaken given by the defendant that they would keep engine produced, put all such royalties into a special joint bank on trust. So it was submitted that the right on which the plaintiff relies is established, that is, confidential information was given to the defendant and that the right has been infringed, and that in all circumstances the plaintiff is entitled to an interlocutory injunction. So basically, in this case, 2 parties were to come together and make and design something. So one of them went out of the agreement and prepared another thing for himself. So that question.
Sorry, can we hear her? Okay.
No, ma.
Was there a secret? Was there that there was actually confidential information, interlocutory injunction? Thank you. That's all.
Thank you very much, Humomot. It was so fast for me, and I'm not sure if it was my internet, but it was so fast for me, and I didn't see your screen moving. So the only thing I can see here is trade secret and confidential information presented by. That was what I saw throughout the presentation. But beautiful presentation, fast, sharp, smart. Thank you very much, Humomot. Okay, it was very fast. Well, you're a lawyer, so I'm sure that one of your skills is this speed, and I think is a good thing. So let's move to group 5. Who is presenting for group 5? Please, let's just go straight to the case that we have to discuss because of time. Who is supposed to present for group 5? Who is supposed to present for group 6? If the person for group 5 is not around, let the person for group 6 start his or her presentation. Okay, so we'll just wait for a minute.
Good evening. My name is Lamoto Yomoshifumi. I'll be presenting for group 6. Our presentation is on the case of McKay. Let me share my screen shortly.
Okay.
Just 1 second.
Okay, if you're not able to share your screen, you can continue. Okay.
Yeah, so I have it here. Okay, yeah. Okay, the case is on McKay Consulting against Rockingham Memorial Hospital. Now, the question we're trying to answer in this case is whether novelty qualifies for trade secret protection. All right, so next. Now, in this case, let me run through this first basic fact, is that we all understand what trade secrets are, and we know that for an information to qualify as trade secret, it must be commercially valuable because it is a secret. It must be known to a limited group of people, and steps must have been taken to keep the information secret. Now, the value of trade secret, or the value of an information as trade secret, has to be based on that secrecy, not on on the value that can be derived on it being kept secret. Now, in this case, in the case of McKay against Rockingham Memorial Hospital, it's between a non-governmental, a non-profit organization and their consultant. Now, the plaintiff, which is the consultant, offered the defendants and offered them information that would increase their reimbursement from the government. Now, as non-profit organizations, they had to be paid. They had to get their benefit from donations. They had to get their benefit from the government. But their consultants discovered a means of increasing their reimbursements 4 times. But before they disclosed this information to the defendants, the plaintiff made sure that the defendant signed an agreement with them. And the terms of the agreement, well, it was oral at that time. It was oral, and the terms were that first, the information that they would share would be kept confidential, and second, that if the information proved as valuable as the plaintiff thought it was, the defendant would reward them. And the reward was a 20% of the reimbursements they got. Now, the defendants agreed at that time to those terms. And even when the information was disclosed, they accepted that it was truly valuable, and they had no idea what it was, that it was their first time of hearing about that kind of information. But upon further consideration, that is, it took about, this case happened in 2009, and the plaintiff met with the defendant the first time in July 2009. But as at October, the defendant had decided that although the information was truly valuable and they were willing to keep it a secret at that time, it was not really a secret. Like, it was new to them and it was valuable, but they found out that other people knew about it, though it was still within the consulting community. It was known by a number of people, but even if the defendants did not know about it as at that time. Anyways, the terms of the contract had to be changed. The defendants wanted discounts, and when the plaintiff refused to grant them this discount, the defendant decided that they were going to discuss the information with another party. Now, this made the plaintiff sue for, they sued on 5 counts. The first was that the defendant had to acknowledge the contract. The second was that they had about 5, and 2 important parts of the claims were that the defendants had enriched themselves unjustly, and then they had misappropriated trade secrets. Anyways, the courts did not agree with them, because in the defendant's arguments, they cited the case of Donin against Southeast Foam Converting Packaging Incorporated, that stated that a crucial characteristic of trade secret is secrecy, not that it is new. So they had to oppose the fact that although this information the plaintiff was sharing with them was truly new to them, it was not exactly a secret. Now, the court upheld the argument. The court accepted that truly it was new. They even cited the Code 59 on Trade and Commerce of the state of Virginia, that stated that it must not be, a trade secret must not be generally known or is readily ascertainable by people who can obtain economic value from its disclosure or use. So this case upheld the fact that while an information might be new and useful, it is not necessarily a trade secret unless it is really known to very limited people, and steps have been taken to make sure it is not exposed. Thank you.
Thank you very much for the presentation, and thank you for the way it was presented. It was well presented. Thank you. So is ready, or should we move on? Okay. So I think that we've done well today. All the mentors have already spoken brilliantly, and they've given us practical, they've given us a practical understanding of how this works and all that. And people have been able to do a good presentation, which I really commend. So I would like to thank everyone. Thank you, Mrs. Chinasa, for coming and staying and for presenting. Thank you, Mrs. Uche. Thank you, Mr. Folarin. Thank you so much for, thank you so much to all the mentees also for coming, for presenting, for researching. And I wish everyone an amazing weekend. Have a great weekend and stay safe. Thank you, and we'll be seeing next week.
Thank you so much. Thank you for having me.
Thank you. Bye, everyone.
Thanks for having me, Juliana. Bye.
Thank you, Sam. Bye, everyone.